So again, my name is Janice Dietz. I'm a SCORE volunteer. You will get a copy of these slides tomorrow. It is being recorded. And Brian usually does a better job than I do of introducing himself. So you're very, very lucky. And we'll take it away, Brian.
All right. Thanks, Janice. Appreciate it. Looking forward to doing another program with SCORE today. We've got lots of exciting stuff to cover in the next hour. So we're going to move pretty quickly. As Janice mentioned, you'll get a copy of the program. So both the deck and the recording. You're welcome to take notes. You're welcome to throw some questions in the box. So if we get those, we'll pause every now and then to answer those. And if, as always, to the extent that you would like to schedule a free call to chat about anything covered in today's program, feel free to reach out offline, and my email's there at the bottom of the slide, so you can take that down and shoot me an email. Happy to get on the calendar with you. And I also offer typically a free legal audit. So to the extent you've been in business, either you just got started or you've been in business for a while, I always am happy to connect up and kind of go through kind of a checklist of items and see where you sit, what you might be doing that you shouldn't, or maybe things you should be doing that you aren't. And so happy to talk through with you what that looks like as well. Again, typically a free process for you. So with that, we're going to jump into today's program. I know we still have people joining, so welcome to the folks who just signed on. A little bit of background for those who may not be as familiar with the firm. We've been around for a long time here in Arizona. We've grown to have over 500 attorneys in our 17 offices, a brand new office in Palo Alto as of a few weeks ago. And we're a true full service firm, so all the resources you might need to start, grow, and hopefully sell your business at some point. Just a listing of those services on the screen. And a lot more information available on the website, including that it's not really a blog, but it's a collection of articles of interest to entrepreneurs and their companies. So feel free to check that out. I try to post weekly, although I've been a little busy the last couple of weeks. So I haven't had a chance to do it, but usually non-legal stuff that's of interest. My role at the firm is to help our emerging business group. So I've been practicing for almost 27 years now, and get to spend my days working with entrepreneurs all shapes and sizes, from those who are in concept stage all the way through to folks who are getting ready to sell their business and everything in between, and handle, as you can see on the screen there, a wide variety of business type transactions, getting companies set up, working through shareholder agreements, operating agreements, day-to-day contract negotiation preparation, helping raise capital, onboard employees and consultants, and obviously handle the merger and acquisition at the back end, or transition to the next generation if that's what you plan to do. So just to kind of tee up today's program, and thanks again for those just joining. What we're going to do is cover kind of 10 areas that we see people getting in trouble with on a daily basis. And you know, these topics really haven't changed. Some of the content's changed, but haven't changed for a long time because people keep making the same mistakes. And you may say, hey, why are you talking about this? Seems pretty straightforward, pretty self-explanatory. Well, it's because people keep screwing it up. And when you screw things up, it costs you a lot of money. The best way to save on legal fees is to do things right from the front end. And everyone wants to pay their lawyers less. So that is really the critical tip. You know, start out with a legal foundation that is solid, or if you're not there, put in place and maybe fix things that are broken. Because once you know, you get in trouble, it will cost you exponentially more to fix the problem than it would just to get it right on the front end. And what we're going to do in each of these slides, time permitting, is to tell kind of what I call a horror story. These are things that really happen to clients that I've worked with, and I think they help illustrate the point. It's a good takeaway. You kind of understand practically what it means if you get it wrong, and so I think that's kind of a powerful tool to have as you go forward. We'll also talk about kind of what I call myths on the street. These are things that people have heard from their buddies. They have read on the internet. There's lots of sources of legal advice these days. Most of it's inaccurate. And so we'll talk through some of those to kind of dispel some of those legal myths that we hear floating around out there and are, you know, harmful to you because you assume that things are X way and they're really not. And so making critical business decisions on that basis can get pretty dangerous. So jumping right into it, number one, selecting the wrong form of corporate entity, or convert if you did. So here are your choices. You've got a corporation, an LLC, or a partnership. No one does partnerships these days, so that kind of gets scratched off the list. Takes you down to an LLC or a corporation. A corporation, when you form it, is just your basic double tax C Corp. If you elect S status, that's a tax election to be a pass-through entity. So those are really your choices: C Corp, S Corp, LLC. And then you can have an LLC taxed as a C Corp or S Corp, kind of a Frankenstein monster, but that is an option. So first myth on the street is that you've got to be a C Corp to have maximum liability protection. That's why you form companies, to protect your personal assets from creditors coming after you. You don't want to lose your house, your kids' college fund, etc. The reality is, if you set up the entities correctly and you operate them correctly, then you will have equal liability protection in a LLC or a corporation. So don't let that be the deciding point. I'm a fan of LLCs, all things being equal, because they offer maximum flexibility. It's kind of blank sheet of paper to structure them from an economic, management, and other standpoint as you like. And there's one layer of tax. So unless you really want to pay more tax than you need to, I think the LLC is a great starting point. And you hear from lots of folks, well, I'm going to raise capital. I've got to be a C Corp, and I got to be a Delaware C Corp. Again, another myth on the street. The reality is, unless you're going public, which few people, if anyone, wants to do that these days, and even if they did, it's probably not a realistic goal given today's markets. But assuming that you did, that was the only time in which you need to be a C Corp. There's really no other circumstance, with very few exceptions, where you need to be C Corp, and most of those exceptions are just not going to apply to you. So it really comes down to whether you're seeking certain types of capital that requires you to be in that C Corp structure. And people look in the newspaper and say, well, geez, I want to get a $10 million investment from a big venture capital firm. Well, the reality is that less than 1% of companies will ever take institutional capital. Most don't need it, some don't want it. And so typical company is kind of what we call Main Street business, that's going to, capitalize itself, maybe get a loan, etc. Founders, friends and family, and others kind of come in as investors, and you grow organically, and you never need to take kind of those big dollars. And so again, with 99+% falling into that bucket, that may and probably is you. And so you can raise capital from lots of parties, and even bigger parties and bigger dollars, in an LLC structure. So the thought that, you have to be in a double tax C Corp to raise capital is simply not true. I help clients all the time raise capital in the LLC structure. In fact, I just got off with a client a few minutes ago who's going to bring in a $500,000 in the LLC structure. It will work just fine. If you're in the wrong type of entity, or you think you might be, then convert to something else. And another kind of tip for the program is, these problems, if you hear of one that maybe impacts your business, they don't get better with time. So it's not a situation where you say, hey, I'm going to wait around and I'm going to give it 6 months and maybe it'll go away. Typically, it just gets worse. It does not get better, and it gets a lot more expensive, sometimes, a ton more expensive to fix it than just getting it done today and kind of swallowing the pill. So first horror story is a company, this a few years back, that was fairly successful company. It had transitioned the ownership from the first generation to the second generation. Second generation brought us in to transition it to the third generation, and it was all in-house with employees. And the second generation folks realized the company was worth 20 million bucks at the time, and they were in a C Corp structure. Now, you can, as I just mentioned, kind of convert from one form to the other, but often it takes a lot of planning. In some cases, it takes years to make it work from a tax standpoint. They didn't have years, they had a few minutes. So we tried our best, but at the end of the day, there was no way within the time frame they needed to transition to get them out of that C Corp for purposes of transferring $20 million worth of value to that second generation. So you can see where this is going. They paid millions of extra dollars in tax to liquidate their position with the company that they absolutely did not need to pay. They could have elected to be an S Corp years earlier and kind of done some pre-planning, didn't do it, and it was a multi-million-dollar mistake. And the cost to elect that status is virtually nothing. So just a first example of how being in the right structure can make a whole lot of sense. And there's lots of other things that kind of go with each of these structures. For time's sake, we won't have ability to get into each of those in detail. But choice of entity is important. Lots of people form S corps because they say, hey, my CPA said that was great. I get to save a couple bucks on withholding tax, which you do. But the S corp creates all sorts of obstacles to growing that may or may not work for you as you go forward. And we've seen it, all the time. So pass-through tax treatment, but a lot of other barriers to growing the company, raising capital, and doing things that you may need to do. So think through whether you're in the right type of entity kind of day one here. So,
Brian?
Yep.
Natasha is asking, do different corporate entities have different tax liabilities? And the second question I'm going to answer, Natasha, Brian's email is on these slides. You can email him for your second question.
Yep. So happy to chat with you offline, Natasha, but the short answer to your question about different tax liabilities. So a C Corp, you pay tax at two levels. The corporation pays tax on profits, and then they distribute those profits to the shareholders, and they pay a second tax. So that's why it's a terrible structure if you can avoid it. The S Corp and the LLC only pay tax at one level, which is the owner level. So that's why one of those two, at least from a tax standpoint, is preferred. The LLC beats out the S Corp, in my opinion, any day because it allows for a lot more flexibility to grow the company, raise capital, and do things that you often just can't do in the S Corp structure. So happy to chat more offline, but that's a short answer to your question. Number two, not protecting your corporate shield. So people assume that you form a company, and I think we may have folks from different places. I know we've got Arizona folks, we have some Utah folks as well, and maybe some other states, but the reality is most people form the company, they've put articles into the Corporation Commission, for example, here in Arizona, and they say, I'm good. I've got my corporate shield, nothing else I need to do. And unfortunately, that is another myth on the street. There's other stuff you need to do to protect that, what we call the corporate veil. Think of it as it's just a fancy legal word for the corporate shield. One, you've got to do the corporate formalities. So if you are in a corporate structure, there's lots of stuff you got to do, even if it's just you as an individual. But certainly if you have more than one owner, lots of protocols, lots of formalities to follow. At minimum, even in LLC, you've got to have your own tax number, bank account. You can't be paying personal and corporate or business stuff out of your personal bank account. You've got to keep separate personal life from work life. And lots of entrepreneurs find that difficult to do. They don't like to get into those details. So they form the company and they really don't separate between the two. That's a great way for a creditor to pierce through the corporate shield. And that we see that all the time. Number two, undercapitalizing your company. So not putting enough money in, either on the front end or when you're going to expand the company to pay your debts as they come due. You can't rack up a bunch of obligations day one, hoping that the revenue is going to kick in and you can pay your friendly neighborhood attorney, you can pay your landlord, you can pay your employees. And if that doesn't happen, you'll bankrupt the company, you'll feel bad, but you'll go home. Not what's going to happen. You will be tagged with personal liability for doing that. So you've got to have enough money, whether it's from your funds, loans, etc., to pay those debts until the company starts kicking in its revenue. And finally, fraud. Obviously, don't commit the kind of fraud you're thinking about, but here we're kind of focused on situation where you leave your employer or get let go by your employer. You've got a non-compete in place and you say, hey, I want to do what I've been doing for 10 years. And so I can't do it individually. So I'm going to form a company to compete because the company wasn't a party to that non-compete agreement. So that should be okay. And unfortunately, you can't do through a company what you can't do individually. And so there would be a potential to pierce through the corporate shield by that former employer. You can still have personal liability for certain stuff. So if you engage in bad acts, you're punching someone in the hallway of your workplace, obviously a bad act. But other bad acts include violating, for example, employment laws that have personal liability attached to it for the owners of the business and sometimes the executives of the business that you may not know about. So that's why it's a good opportunity, a good time to go through that legal audit I mentioned at the beginning of the call. And for those who just joined, you can take advantage of that as well. I'll mention at the end. But there's laws that exist to protect, in that case, employees, and they say, hey, if you're not paying your employees correctly, we're going to hold the owners of the company on the hook for that. And even though you have your corporate shield in place and you're doing all the other good stuff, that could be a source of liability. Another one I like to highlight, and this is our horror story for this one, is personal guarantees. You often have to do those for SBA loans, for landlords, for other things. Get off the guarantees as soon as you can. Don't forget about them. We had a client back in 2008 getting ready to sell the business, and it's been a while, but I think it was kind of a $60–70 million type size deal. Family business, been around for a while, good guy running it. We were helping with that process, and we said, hey, you have a lot of personal guarantees. You might think about paying those off. And he said, well, it's kind of a pain to deal with the banks and get all those paid back. Let's just do it when we close the deal. We'll just do it all at one time. We'll take the proceeds from the deal to pay off the loans. It'll all be good. So, okay. Well, if you were around in the business world in 2008, you know what's coming. So within a very short period of time, probably 30–60 days, the market crashed. His industry completely got wiped out. His business went to zero. And instead of selling it for, 60 million, he went bankrupt. And at that point, the banks did not say, well, we feel bad that you lost your company. You know what? Forget about those guarantees. No, they called the guarantees and essentially put him into bankruptcy as well. So again, another completely avoidable situation, but just, didn't plan accordingly. And it was, just a tragedy. But again, highlights the need to pay attention to those obligations where you are personally on the hook, because it's very easy for life to happen. COVID hits, market crashes, there's all sorts of things that go on, and you can't predict when that's going to take place. So prepare accordingly. Number 3.
Brian, before you start number 3, Natasha is also asking, what if you do business in multiple states? She's asking what would be the recommended structure?
Well, we're going to get to that right now. So good question. So point number 3, putting all your corporate eggs in one basket. So there's ways to kind of put fences around your operations so that if something blows up in one place, it doesn't take everything with it. You can do kind of a parent or holding company subsidiary structure, which some of you may have heard of. You can do a affiliate structure, lots of different ways to do it. But you can put fences around your operations and or assets. So for example, if you own the building you operate the business out of, good tip would be to take that building, put it in a fresh LLC, and then lease the building to your operating company. If your operating company goes bust, that real property will be safely tucked away in the LLC. It won't be impacted by that, the crash of that operating company. Or, to the point of the question, you can set up a separate LLC to do business in a different state or a different country. Or if you're doing a second line of business that maybe comes with higher risk, you can work through that in a way that and set that up so that if that higher risk business again gets a claim or collapses, it's not going to take down both businesses. Or you're doing business in Mexico and something happens down there, different regulations, or maybe overseas, it doesn't take down the whole company. So lots of ways to do it. You can do it if you're just getting started. You can do it if you are you've been in business for 10 years. There's a lot of ways to make that happen. You have to be treating your fences as though they exist. In other words, you can't lease your building or say you're leasing your building from one company to the other, but there's no lease in place. There's no rent being paid. You've got to actually pay yourself rent at a market rate. You don't have to have a 400-page lease, but you got to have a lease in place and treat it as though, you don't own the building, or treat it as though you don't own the operating company. So in other words, if you were leasing it to me, you're going to have a lease in place. I'm going to pay fair market rent. And so kind of think of it that way, and it's a kind of a good guideline for you. And so as long as you respect your fences, that structure you set up will be respected. So the horror story here, this one fortunately ends okay. Situation where the client was building a software company in an existing company they had. They were going to wind down the existing company, spent about 200 grand building the software product, which was going to be their next venture. Didn't take it out of the existing company because they were using profits from that company to pay for the development. the existing company gets hit with a class action lawsuit, all of a sudden that software is now potentially, an asset that those people suing could get after. And so you can't just take it out of the company and say, wait a minute, didn't intend that to be in there, that 200 grand worth of software development. We're just going to pull that out and you guys can get the rest. No, they now had a claim to that if they were successful in the lawsuit. So long story short, we had to set up a second company and essentially replace the software with cash. You could trade software for 200 grand. And if the plaintiffs won that lawsuit, they get the 200 grand. That was a fair swap. And so we set up a new company. They were kind of paying themselves for a few payments. Fortunately, the lawsuit settled, but had it not settled, the end result would be they had to pay for the software twice, once to develop it, once to pull it out, and it would have doubled the cost of development, which is, again, completely avoidable had they thought through that ahead of time and tucked it away in a fresh company before getting started.
Brian, I have two questions now.
Okay.
The first is from Natasha for a second time. She said, if you have a DBA, does it need its own LLC? And then I'll ask you the second question when you're done with this one.
Yeah, so the DBA is doing business as kind of a marketing name. So no, that you can have LLC, ABC LLC, but doing business as XYZ. So it does not require, it's not an entity. It's just how you refer to the business. And you might think about getting a trademark on that doing business as name, but yeah, it doesn't require a separate entity.
And the next question from Kylie, is there a big difference in this scenario between an LLC and a PLLC?
Yeah, so the PLC is a professional limited liability company, and at least in Arizona, it's more optics. You see lawyers doing it, doctors doing it, et cetera. And so there's not a lot of difference, frankly, from a corporate standpoint. It's really more of optics, right? They want to be designated as a professional limited liability company because it adds a little additional kind of cachet to the name. So, but yeah, depending on the industry, and usually there's not, at least in Arizona, there's requirements of who can do it, right? You can't be a doctor having a PLC if you're not a doctor type of thing. That'd obviously be odd. But you can, use that designation, assuming you meet the licensing criteria, to add that to your name, and again, more from I think from a marketing type purpose. So that would be the answer to that one. So this is probably my favorite slide. Of all 10 mistakes, this is the most catastrophic, even though you've heard some horror stories already. If you have any partners in the business, you need to have a shareholders or operating agreement, because you will disagree. And for folks on the call that say, hey, I'm just in business with my family, no issue, we get along. The family disputes are the nastiest things we ever see, because you've got the business issues and then all the family dynamics on top of it. We've seen, I talked to a client today whose aunt was about to sue her. We've seen an identical twin brother suing a brother. We've got a case right now where a son is trying to do horrible things to his mom. I thought I've seen it all, and this is kind of a fresh one. So you're going to disagree, and one of the myths on the street is that the statute under which you form your company, again, Arizona, Utah, Delaware, whatever, will provide a playbook for you to resolve issues, and it will not. It addresses maybe 10% of the 20% of the issues, and even the way it addresses those may not be the way you want it to be addressed. And the other 80% or so are not addressed at all. And so you get into an issue, and there's no guidance. There's no ability to do anything that you need to do to fix the problem. And so the purpose is getting this in place. You see on the screen, kind of align expectations, allocate all those rights, the management, economic, information, et cetera. And when stuff happens, and it will happen, right? People want to transition out of the business. Life happens, someone dies. Someone does bad things, and you want to expel that member from the business. Things will happen, guaranteed. And you have to have a playbook in place for how to address those things. So the horror story here is truly the worst of the day. So I think it gives a great kind of example of how, when you hear the story, you'll say, well, geez, if the state statute doesn't allow you to kick a member out, if that happened, then clearly it doesn't allow you to kick a member out for anything else. And so we had a situation where we had a company, had a person owning a portion of the company, was on the board very well credentialed person, older person who'd done a lot of cool stuff in his space. Company was happy to have him. And they were about to go raise more capital, so they went out to call on their board members saying, hey, we'd like to get your help. And this particular gentleman, they couldn't find him. And they know maybe he moved, changed his number, wasn't responding. So they thought, well, we'll Google him. Maybe, maybe something happened. So they Google him. They find out that in his time since they last chatted with him, he's been busy. He went out and tried to take out his ex-partner, his ex-wife, and ended up shooting his ex-wife's brother. Fortunately, he didn't kill him, but something snapped. And you would think someone's attempting to kill people, almost did. That would be a reason under any state statute to be able to kick him out as a member, take back his ownership, and get him off the team. And that is not the case. So ultimate end of that story is, no one died, although they came close. And we ultimately got his equity back, but it was a very difficult process because obviously he's focused on more important things to him, like not going to prison forever, which he did. But that is, I think, the best example. There's lots of other examples, but it is extraordinarily difficult, if not impossible, to get people out of the company, even who do horrible things, commit felonies, all sorts of stuff, if you haven't baked that into your operating agreement. And people will go sideways, people will disagree, and you want to have that playbook in place to prevent the company from getting destroyed. Shareholder disputes are one of the top 3 causes of litigation pretty consistently. And the minute someone calls up and says, hey, I've got a partnership issue, we ask, hey, do you have an agreement in place? What does the documents look like? It'll take more just to get up to speed on the issue than it would have cost you just to get the agreement in place. So when you start thinking through kind of penny wise, pound foolish, and how best to allocate your limited legal dollars, these documents are worth their weight in gold because, if anything goes sideways, and it will for sure, even if it's just someone who wants to exit the business and there's no way to facilitate that orderly transition, you're going to cause harm and damage and maybe kill the company. We've seen that happen lots of times.
Ryan, Natasha is asking again, what are the recommended insurances to have for your business?
Well, I mean, it depends on your business. I mean, you want to have your general liability insurance. You probably have to, have workers' comp if you have employees. You might want to have some D&O insurance, depending on how many owners you have. You may have insurance specific to your industry. If you take a cyber insurance, popular these days, a lot of data breaches going on. So yeah, there's kind of the typical array of stuff. The best advice is to get with a good insurance broker who can kind of talk through the ins and outs with you. Can kind of offer different options. Doesn't work for just one insurance company, but can kind of bring in a variety of companies and can kind of customize that for your business, because it's not one size fits all. Even though the most common coverages are pretty standard, there may be specific risks for your business that you want to make sure you capture. So my thought would be to get with a good broker who can kind of guide you through that process. So raising capital. People tend to do this here in Phoenix illegally on a daily basis. They don't know the rules, or they know them and don't care. And so it's kind of Wild West-like here. And we always tell people there's 2 areas of law you don't want to mess with. One is something everyone gets, and that is pay your taxes. You don't want the IRS kind of coming in, or the state tax folks, and making life difficult. What people often don't know is that the securities regulators will make life equally difficult for you. And so that's the second area where you just don't want to cut corners. Getting it wrong and getting tagged with securities fraud is life-changing. It'll pretty much ensure that you don't do any more entrepreneurial stuff going forward, or at least make it extraordinarily difficult to do that. You'll never raise capital again, probably. And so what are these rules? Well, and I should have mentioned kind of earlier on, I do lots of these presentations, both for SCORE and for other groups. And so at the end, I'll show you some upcoming programs. And a lot of these topics we have a standalone program for. So if you're saying, hey, I'd really like to learn more about that shareholders agreement, or I want to learn more about how to raise capital, typically have a standalone program on that topic where you get a deeper dive with that. So on the raising capital front, suffice to say that before you go out and chat with anybody, put up a website, put an ad in the newspaper, do a blog where you talk about raising capital, you've got to have picked out a legal path to raise capital. And there's certain paths that you can take to do that. They're based on kind of these factors you see on the screen: how much money you're raising, how you're doing it, etc., who you're raising it from, what your relationship is to those investors. And so we typically will talk with folks and say, hey, based on your criteria, how you want to do it, you have 2 options, 3 options, maybe just 1 option available. And each of those options dictates a certain set of requirements, types of documentation, types of process, who you can talk to, whether you can advertise and make public your offering, or it has to be more limited to those who are in your family and friend network. Final thing I'll mention, again, if you're thinking about raising capital, strongly encourage you to come to the standalone program. But one thing we see people getting tripped up on constantly is the so-called finder. You know, you may need to raise, you know, 500,000, and you meet someone at a you know, some kind of a networking event for small businesses, and they say, hey, you know what, I can help you raise capital if you give me a piece of the action, maybe give me 10% of what I help bring in the door. I'll help you, you know, source investors. Unless they are a licensed broker dealer, it is illegal for them to do that. But you see lots of folks running around here in other cities who tell you that, no, I figured it out. You know, I got some legal advice. It's all good, and we can do it. And you know, there's some smart people out there who are pretending that it's legal when it's not. They get in trouble, you get in trouble. And by the way, the securities, if you get it wrong, it's a felony. So it's not a traffic ticket. It's not, you know, a small issue to deal with. It's a personal liability at the felony level, and that's just simply not something that you want stapled to your entrepreneurial resume. So be wary of the finder. We just had to tell a client the other day, and this probably comes up at least once every 2 or 3 weeks. You know, company X is up there, and they say they do this all the time. They've done it for years. They've helped raise, you know, $50 million, and you know, they've been doing it illegally. So you don't want to be in that bucket. Horror story here happened a few years ago, pre-COVID, when we, you know, most of these seminars were live. We had someone come up, as was the case historically, and they come up after and say, hey, I've, you know, done a lot of deals and I never heard of these rules. So this guy happened to be a 10-year veteran in the real estate space here in Phoenix, and said, hey, if you're willing to help, I'd like to find out how to do this correctly, because I've been lucky, but you know, I don't want to press my luck. And so we had him come in, gave him some homework. He went off. I guess he didn't want to do the homework because he brought a couple of buddies to the second meeting. We gave him the homework again. And then he called me up a few months later. So the time between the seminar and the third call was 6, 7, 8 months, very short. And he said, I urgently need to meet with you. I'm like, great, you got your homework done. No, not quite. So in that short period of time, someone had turned him in to the state securities regulators. So you've got the SEC at the federal level, which you may have heard of. And granted, those guys are focused on the big dogs, you know, kind of billion-dollar frauds and kind of related things. But the state regulators are focused on the small fish in their state. Someone turned him in. It just took one person, as it typically does. And they're on the hunt, and they've got unlimited time and resources to go after those people. And we say, well, we'll, you know, try to set you up with some folks here we think may be able to help. And we'll never know what happened, because he left the state and he never came back. And so, again, this is simply not an area where you want to cut corners. If you want to raise capital, do it the right way. It's not that hard. If you work with someone who does this on a regular basis from the legal side, happy to help. And it doesn't cost a whole lot to do it, but you've got to do it the right way, or it can lead to all sorts of issues. And if you read the local paper in your city and pay attention, you will see lots of articles with the state regulators kind of, you know, indicting people, etc., for, you know, fairly small investments. It's not like you have to raise 20 million to get on the radar. You could raise 200,000 and do it the wrong way, and it's going to put you in jeopardy.
Brian,
Yep.
This is a long question from Darren. He says, I understand you can create an LLC in any state, say Wyoming or somewhere not where we operate. I'm in California and understand creating an LLC in Wyoming is significantly cheaper on an annual basis. Is there any reason not to create an LLC in the state you are operating, or any other tips that I should consider before creating an LLC in another place other than where business is located? Downsides? Thank you. Now, what you might want to do, Darren, is email Brian this question because it's a long one.
Yeah, that's happy to chat with you offline. That's really fact specific to your situation. But bottom line is, if you're in California, you're not going to get out of the crazy taxes that they put on you to operate a business. So you could form in Wyoming, you can form in Delaware, and there's, I mean, really any state's but more business friendly than California for sure. But you're going to have to qualify to do business in California because you're doing business in California. So they're going to get you on that side. So yeah, each state comes with different pros and cons. Delaware has historically been pretty kind of a default state, although that shifted a little bit when Elon Musk was fighting with Delaware about his bonus package, as you may have seen in the news, and moved his company to Texas and reincorporated. So you're seeing some of that happen. Texas, very business friendly. One of the myths on the street is if you live in a state with no, or if you form an entity in a state with no income tax, like Nevada or Texas, that you don't have to pay any income tax. And that is not true. If you live in a state with income tax, you'll pay that state's tax, even though your company is formed in a state where there is no income tax. You actually have to be in that state. You have to live in Nevada, for example, to take advantage of that. So, but yeah, you're going to have to, you can form it wherever you like, form it in a business friendly state, but then if you're not in that state, again, no one's in Delaware really, but if you have your business in California, Arizona, you have to qualify to do business where you are at, and maybe multiple states if you're doing business in multiple states. And that will trigger typically the tax implications to be there. So happy to chat more with you about, which state may make sense for you specifically. Again, there's more factors to it than that. It also impacts if you're going to bring in investors. I know some people form in Wyoming. That's really not a favorite for investors. If you got people you're raising capital with, and they're from all over the place, Delaware is still a good default place. It's not hasn't fallen totally out of favor, so that could be. And we form lots of Delaware entities. So if you're in Arizona, Arizona's still very business friendly, so you can just form it here and you're good. California, unfortunately, it presents some challenges. So, but happy to chat more with you offline.
Darren, at the end of this, I'll ask Brian to bring up that first slide, which has his email on it, so you can wait and take that down then.
Yeah, and I'll be happy to put it in the box as well here. Just type it in there so you have it. So number 6, failing to protect your IP. Everybody has IP, even if you think you don't. People say, I don't have any patented widgets, so I don't have any IP. You do have IP. You have the brand to your company. Your name, your logo, your catchphrase. You may have a proprietary trade secret formula for your product. Everybody has something. And so you want to figure out what you have and you figure out how you protect it. That may be kind of the core value of the company, protecting that proprietary formula, or it may just be that brand is everything. You do stuff that 20 other thousand trillion companies do, but you're doing it better. Or at least you think you're doing it better. And so that brand is what stands out. That's going to be the value. And we've had lots of companies sell and make lots of money at sell time because they did what others did, but they were able to create a brand that stood out. And that may be what you need to rely on. So you need to confirm you own it. Law, imagine, is not always intuitive. So the big thing we see people get sideways with is they have an independent contractor create a website or create a whatever for the company software. And they say, well, I paid the person. Of course I own the software, the website. You don't, because the law defaults to the contractor owning it. And they say, that makes no sense. Well, it doesn't make sense, but that's the way it works. So you've got to get kind of magic assignment language in the document. And I guarantee you, your contractor who's the software guy is not going to have it typically in their agreement. It's probably not going to be addressed at all. And so you need to put that magic language into the document so you can protect stuff by filing, patents, trademarks, using confidentiality agreements, and states were allowed. You can use non-competes. Again, sorry to Darren, because you can't really have many of those restrictive covenants in California. You still can have lots of those in Arizona if they're properly drafted. The horror story here, we had a company that had a pretty common product, nothing special. but it had really attractive brand names for the products, each of the little products. And it was a consumer business. And they went to sell the company. It was a $20–30 million deal. It was a while back. And the buyer figured out, probably late in the process, that they didn't own any of the trade names, trademarks for those products. And that was a big part of what they were paying for. The brand is what sold the products. And so we're not going to pay you 20–30 million if you don't own these trademarks. You got to go get the contractors that are creating these to sign them over. And so the deal was supposed to close December 31st. People were on vacation literally all over the world. We spent a week. They spent the week tracking these people down all over the globe. And fortunately, they had a good relationship with them, so they signed them over for free. This one ends well. They could have extorted them for several $1 million to get them to assign them to get the deal closed. Fortunately, they didn't do that. But that half sheet of paper could have been the difference between closing a major exit for these owners or not, or getting extorted along the way. Again, just another example of how little things can make a huge impact. Number 7, there's no better way to get yourself in trouble other than the securities rules than in the employment arena. So a few things to think about. One, at least half of the people are looking for a new job, right? Notwithstanding the current kind of economic chaos we see today, and regardless of what your political persuasion is, I mean, people started off the year pretty optimistic. Hopefully we stop the chaos and get back to that. But nonetheless, people are looking and saying, you know what, I think I might want to leave. I might want to get a new job. That may be great for you, or it may be a challenge for you. You may potentially lose some good talent, or you may be able to poach some talent from a competitor. You need to figure out how to, make that something for your advantage or protect your current resources. There's a proper way to hire and fire people. Again, for time's sake, can't get into all the details, but we see people do it incorrectly all the time. And you hand people on the way in or on the way out claims against you that you simply didn't need to do. And we'll talk about a catastrophic horror story at the end here. You have to understand what people want. New phrase heard recently, the great detachment. No shocker here. People are all want to work at home, completely removed from the day-to-day workplace, and now they're complaining that they feel detached from their company. So who could have seen that coming? But that's the reality we're dealing with. People who want to feel a part of their workplace, connected with the culture, but don't want to show up in the office. And we have the same challenge here at our firm. And so I don't know what the solution is. We probably could talk for hours. I have my own thoughts on it, but suffice to say, that's a big challenge. There's also generational differences between what the older folks, and I'll put myself in that camp, want. You paid us more as Gen X, and we worked harder. It was real simple. The current generations want different things. It's not necessarily dollar motivated. They want to get paid, of course, but there's other things that really become important. There's a great resource. MetLife does an annual study. You can download it for free. I think they're on their 20-something year, and it's got a ton of information in there about what different generations want and what employers think they want, and it really can give you a good sense of the expectations they have and maybe how you can better meet those to kind of create that type of culture and that retention that you're looking for. There's also other ways to incentivize folks, whether it's a performance bonus, it's giving them ownership, or something that looks and feels and smells like ownership, but is a lot simpler for you as the employer, the owner. So happy to chat with you offline on those things, but lots of tools that lots of people don't realize are available. Some of the hot buttons, everyone wants to treat everyone as a contractor. In California, that's almost impossible if they kind of do what your business does. Although I did see today that the administration is kind of pulling back Biden's stuff and putting back in the kind of the first term Trump stuff, which is, more flexibility for company owners versus, totally slanted toward the employees. So we'll see where that kind of lands. But bottom line is, just because you and the contractor agree they should be a contractor doesn't make it so. There's federal, state, local rules that govern that relationship. And if you get it wrong, there can be all sorts of consequences, as you'll see in our horror story. You can also have personal liability. Person's supposed to be an employee. You characterize them as a contractor, which we know everyone wants to do as an entrepreneur. It's easier not to pay the taxes. And they were supposed to be on workers' comp as an employee. They're not. They get in a car wreck on the way to work. Guess who may be personally liable for those damages? That may be you as the company owner. So lots of ways in which violating employment rules can bite you personally and not just the company. Same thing with hiring people and making everyone a salaried employee, because that way you don't track hours. There's rules that determine very clearly whether they fall into one bucket or another. And if they don't fall into the appropriate bucket and you get it wrong, it can be significant liability. So on the discrimination harassment side, obviously don't do it, but you can't stop some joker in the workplace from doing bad stuff. But you can put policies in place, procedures to deal with it if it does happen, that can shield the company from substantive liability. Again, you can't prevent the joker from doing it, but you can put in place policies to help mitigate the liability and address the issue as it arises. The horror story here is fairly recent. Company was going to sell, again, I think it was in that 50, 60, $70 million range. And they had hired a whole host of people, like half the team, as contractors. Business has been around for a long time. They found a buyer. The buyer was a public company and said, hey, I'm not coming near that. That is a hot button issue. We can't be doing that. You've got to convert all those contractors to employees, then come back and talk to us. Well, they did it quicker than I thought, but they had a long time to do it. They just never did it for years and years and years. And they came back in 3 months. In that 3 months, the market had fallen out in that particular space. Deal was off the table. It's still off the table, probably for good. So, that hiring mistake, which they remedied pretty quickly, cost, 50, 60, 70 million bucks of a sale. And that deal, it looks like the company is going to have to pivot and do something else, given how the market's just changed in the past. It was probably about a year and a half ago. So again, if you see a theme here, little things, little mistakes, huge consequences. So encourage you to think through, these items we're talking about. And if you're, again, interested, go through that legal audit to see where you sit on all these items. Failing to use commercial contract best practices, you're going to have to deal with contracts no matter what business you are. The most cost-effective way to use your legal dollars are to create your own forms for customers, employees, contractors, etc. It is ridiculously inefficient to vet each customer agreement as it comes in. I know some people are in certain industries saying, well, the customer is, we're dealing with the government, we have to use their form. Okay, that's the exception. But for most of you, you can create your own form. Now, the customers may have comments on it or they may have questions, but it is exponentially simpler, more efficient, and far more cheaper from a legal standpoint to have good forms. You know what's in them. They protect you. You've limited your liability. They capture the business deal. And we can talk. And in fact, we do lots of standalone seminars on this topic. So feel free to check one of those out. But bottom line is, you've got to get kind of educated on what the key business terms are. You see some of those listed there. And by the time people get past the business deal component and start getting into these things called reps and warranties and indemnities, it just sounds, either A, it's boilerplate, and B, it's too complicated, so I'm not going to worry about it. And it could be one sentence that tips the scale. And we see 1 or 2 sentences, have a catastrophic impact to the company, sometimes put you out of business. And it sounded fair. Let's be on the hook for a data breach. That's fair. We're taking your data, we're taking your information, your credit card, whatever it is. And yeah, if someone breaches our system, it seems fair. We take that liability on. Well, they find out that it's extremely expensive to deal with those claims. I mean, the typical data breach kind of claim is continuing to increase almost daily. And it's, if it's not hundreds of thousands, it's in the millions, and it's just, company ending for a small business. And again, you can do lots of stuff to say that I'm not on the hook for that. We can't guarantee we won't be breached. I mean, no company can. So we're not going to be on the hook to the customer for that. So lesson learned here is no damage limitation. It's kind of a funny one, but I think it goes to the fact that people like to get their legal advice from buddies or the internet. So in this case, the client calls up and says, hey, I'm pretty concerned. We've got a claim. I think it was, I forget the number. It was tens of thousands of dollars. And they said, you know what? I looked at the agreement. I'd like you to look at it. I'm concerned there's no damage cap. And I said, oh, okay, send it over, take a look. So they call back and say, you know what, I reviewed it real quick. I think I'm okay, but I still want you to take a look at it. So I take a look at it, call them back and say, hey, bad news, no cap on your damages. So what do you mean? I got this from my buddy. He said he spent a bunch of money with a lawyer to get it done. It's in there. I know it's in section 15. I said, yeah, but do you know what it says? Because what it does is protect the customer. It says the customer is limited, liability is limited. I said, what do you mean? I got this from my friend. I said, what side of the deal was your friend on when they got this contract drafted? Well, of course, it turns out that the friend was the customer on the customer side and had it drafted from that standpoint. So protected the customer, the guy, my client, was the service provider. And so he had no cap on liability and didn't put him out of business, but it was really, really painful. And again, a couple of sentences, he thought it protected him, didn't understand how that worked. And a couple sentences could have saved him tens of thousands of dollars in damages. And without that, there was no shield, there was no protection. He was on the hook for the full boat of damages claimed in that situation. So think about creating forms that you will be able to use that are, again, that what's in them, you educate yourself, and then you can, use your attorney sparingly instead of having to make, lots of calls each and every time a contract comes in. Number 9, those who've been in arbitration or litigation, I'm sure, never want to do it again. And the key here is to identify issues or situations that lead to litigation and try to avoid those. So we don't have time to get into all these, but lots of reasons why people get into battles. And sometimes, things are obvious, sometimes not. You may have a no agreement or a bad agreement. You may have failed to create kind of a trap door to get out of a contract that is not working. It may be simple failure to communicate. In the electronic age, people tend not to do a live meeting, let alone a Zoom call and other things, and so they just send electronic communications or short form text or whatever, and it leads to lots of misinterpretation of what's going on. And a couple of big things, doing business with unethical people, no matter how good the contract, if you got bad folks on the other side, it's going to make life miserable, and they're not going to follow the contract, and they're going to do things that are going to cost you a lot of money. And finally, understanding that people tend to get some people really emotionally invested in a fight. And we have a good example where we had a brother and sister fighting. At the end of the day, it came down to, I think, $5,000, the delta between what one wanted to give the other. Our client was so animated about this fight that they were literally, until we talked them out of it, willing to spend a couple $100,000 fighting the sister because they didn't want to pay the $5,000. And we said, that's insane. Don't do that. Just pay the $5,000. Let's be done. And they ultimately did. But they were totally ready to go to war over this because the emotional side, overtook rationality. And that happens all the time. That's why litigators can send their kids to college. So the strategies are kind of the reverse for the most part. Work with ethical people. Take informed business risks. So we've been talking through the last hour about risks that you can control. Lots of risks you can't control. Why not mitigate the ones you can? Make sure that you have good documents in place. Not hard to do. Few people do them, and it comes back to bite you. Understand the rules and laws and follow those. We've talked about some of those that maybe aren't well known or intuitive, the employment rules, the IP ownership rule, etc. And finally, do not, when a dispute arises, just kind of fire off, a response or get kind of go on the offensive immediately. Get a reality check. We do that quite a bit, and kind of, we don't have any dog in the hunt, and we kind of come in cold and say, you know what, let's first of all look and see whether there's actually an issue here, because people tend to sometimes think there's a problem, there's not, and they go to war over nothing. In another case, they will send off crazy emails. We've had this happen recently where the other side has given us so many crazy texts that, if it ever goes to court, man, it's nothing's ever a slam dunk, but it's pretty close. I mean, if the jury gets a hold of these emails, they will think this person is a horrible human being, and they did it to themselves. They just kept firing off emails to the other side, then they fired them off to us when we got involved, and it's crazy stuff. And don't do that. Take a pause, sleep on it. Don't send out one text or email that'll destroy your credibility in a courtroom setting. and figure out how many, kind of what your leverage is. Sometimes people want to go to war and we say there's no bullets in the gun. You're going to point the gun, there's nothing in it. And sometimes you bluff as a strategy, but you want to know what your leverage is. Sometimes there isn't any, or sometimes you have a lot, but you got to do that assessment before you go into battle. Otherwise you're flying blind and people get hurt that way. So just understand that people act completely illogical in many cases. And even though you're totally in the right, there may be a situation where you say, hey, don't fight this person. They're not stable. And if you don't give them their, $50 back or their $10,000 back or whatever it is, you don't need to legally. But if you don't, they're going to spend the next 6 months, destroying your reputation on the internet. And good luck trying to take down all those posts. And is it really worth it, right? And you say, yeah, this person doesn't deserve a cent back, but on the other hand, I don't want to have my brand damaged. So let's just call it a day and do, what makes sense for the business, even though, again, contractually, you're not required to do it. Finally,
Before you start number 10, just want to reiterate that you will get slides tomorrow after he's done with number 10. If there are any other questions, I will ask them. If there are none when he's done, then we'll end the seminar and you'll get your copies.
All right. So number 10, not planning for an eventual liquidity event. So people assume they've got forever, and you don't. Life happens. COVID obviously taught us that. People die unexpectedly. Laws change, competitors come in, industry changes. And so you should have a plan A, but you should have a plan B as well. And the best way two things to do. One, make sure that you understand what the value of the business is when you go to sell it, right? People tend not to focus on that until they're ready to sell. And we've had people, this is the horror story, work in the business for 10, 20, 30, 40 years. We've had clients that are in their 60s, and they heard a long time ago that their buddy sold their business for a 10 times profit. So most businesses will sell for a multiple of an annual profit number. You made $1 million, it's a 10 times multiple, it's $10 million sale. Every industry has a different multiple, and different size businesses within the same industry have different multiples. And just because your buddy sold his tech company for 10 times doesn't mean your insurance practice will do the same. And so we've had people literally work until their 60s, ready to retire, exhausted, find out that their business will not sell for anything near what they hoped it would be. It's much, much, much less. And they sell the business, pay off debt, have a nice lunch, and go back to work. And it's absolutely tragic. Totally avoidable, because you could learn today. And for those on the call who are just kind of getting started, figure out what's that look like on the back end. And know that that's, you have to grow the business to X amount for X sale, and don't rely on deals your buddies did or you read on the internet or read in the paper, because again, it's specific to your particular type of industry and size of business. Second, kind of run the business every day as though it's for sale, meaning do the right things, close the loopholes, fill the, do the best practices. I mean, all the stuff we've talked about today, obviously this isn't exhaustive, but these are kind of the top 10 things we see constantly, and de-risk the business. So if you have to activate plan B because, things happen that you didn't expect and you've got to sell, 5 years sooner, you didn't, for example, like I think it was first or second slide where they paid an extra tax bill on $20 million, and they could have avoided that and put those dollars in their pocket. Totally avoidable, but they didn't plan ahead of time. So with that, I'm going to tell you to get your legal checkup. Happy to do that legal audit with you, free of charge. So let me know if you're interested. And notwithstanding, always do a checkup, at least once a year, because rules change. So you've got a good non-compete in place in Arizona, and we've had clients where it's sat there for years and years and years, and they come back and say, hey, that employee left, I got to go after him. Well, that non-compete you wrote 8 years ago isn't enforceable today because the rules have changed. So you've got to kind of get updates. It's not a once and done. You got to get a checkup and find out, hey, is there something that's different now? We've got to upgrade. The rules are always changing. So with that, I'll just tell you about a few upcoming programs. All the seminars are listed on the website down at the bottom, so feel free to jot that down. We're covering a variety of topics that we talked about briefly in today's program, doing a much deeper dive. So these are all virtual except for the ones live, so you can if you're here in Phoenix, you can check the live one on how to raise capital. But if you're not, there's going to be a virtual one on that one coming up as well. And finally, for those who have attended our emerging business program in the past, we've been doing it for 16 plus years. I've finally given in to the post-COVID world, and we've decided to do both virtual and live programs. Historically, it's been all live. So we're going to do kind of 2 live or 2 virtual a quarter, 1 live a quarter. We've got a live one coming up in a couple of weeks. So if you're in Phoenix, check that out. If you're not, our next one will be in, I think, August, and that'll be virtual. So with that, we'll wrap up right on time. And if you've got any final questions, I'm happy to stick around for a couple of minutes to answer those. If not, you'll get a copy of the deck, copy of the program. And again, if you want to schedule some time to chat offline, happy to do that. So any questions in the queue there?
No, I don't think so. And let me go back to the Q&A. No, there's only one there. But remember, he has up here his own email, burt@swlaw.com. But then he had his website on his other slide. So you're going to get lots of information. But believe me, the templates that SCORE has on their website are unbelievable things for you to start. And this is probably one of the most demanded webinars that we have, because you had 15 people here, but you probably could have helped a lot more. But thank you so much for all of you for coming, and you will get the slide tomorrow. You can contact SCORE at any time to get some help. And let's go. I'll give Brian a big round of applause.
All right, thanks for having me, everyone. Appreciate it. Hope you enjoyed the program, and we'll hopefully see you at the next one.
Okay, thank you.
Take care.
Okay, that was great. All right, I'm going to end this. Okay.